Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. I have an office located in Westport, but my office is really everywhere online. And with me is co-host Jane Faherty, who's the director of the JumpStart program at the Stamford JCC and a special education advocate. We're honored to have two guests that we'll get to in a moment, Steve Ehrens and attorney Jim Funnell. We'll get to them in a moment. Jane and I are now completing our fifth year of these webinars, and we're still continuing to learn and deal with issues affecting children and families of children with disabilities. We're part of a professional community, and for the past years, we've been moderating a series of webinars on a variety of topics. Tonight, we're focusing on financial planning instead of special education and similar issues. So it's a change for us. We continue through these webinars to address social, emotional, and educational impact upon our child, your child, our children, our clients' educational journey. We are fortunate, as I mentioned, to have two individuals who will be discussing special needs trusts, power of attorney, guardianships, supported decision-making, estate planning, financial planning, ABLE Act account, SSI, which stands for Supplemental Security, and Medicaid, which some people refer to either as Husky or Title 19. I have a disclaimer. First of all, this webinar is being recorded. A copy of the webinar will be provided to each person who is registered. The information during this webinar does not constitute specific legal, educational, professional, financial advice regarding you, your child, your family's circumstances, and should not be relied upon as such. The webinar does not establish an attorney-client relationship with myself or attorney Funnell, or a professional relationship with Jane Faherty, the Stamford JCC, or a fiduciary or professional relationship with Steve Ehrens and Northwest Mutual, who he represents. By signing up, you agree to receive emails about future webinars and events from the Stamford JCC and the Law Office of Lawrence Berliner, LLC. Please note that Zoom is a third-party provider and not an agent or associated with the Law Office of Lawrence Berliner, Stamford JCC, Jane Faherty, Steve Ehrens, or James Funnell. The information provided is based upon Connecticut law, and for those that are coming from other countries and other states, we welcome you, but you need to check your local jurisdiction because what we're talking about tonight is based upon Connecticut law, and there are variations, especially in the field of trusts and estates from state to state. If you're watching this webinar from another, I've already handled that. Before I begin, I just wanted to offer for those who are in Connecticut and those around the country, there are some fundamental changes taking place as we speak tonight in Connecticut special education law. For those of you who may have shown up at the Connecticut General Assembly or submitted testimony as I did on House Bill 7277, an act concerning special education, our House of Representatives passed that unanimously 148-0 the other day. And I think yesterday, the state Senate passed it unanimously about 35-0. This legislation will have a grievous impact and harm on children with disabilities in special education in Connecticut. If you are concerned, please contact Governor Lamont's office and urge him to veto the legislation. On the federal side, you've probably been watching the Budget Reconciliation Act and other things that are going on in the House of Representatives. A budget bill was passed by a vote of 215 to 214 last week in the House of Representatives. The United States Senate is considering that legislation, which will also have an impact on Medicaid funding, special education funding, and many other programs that serve adults and children with disabilities. So if you're concerned about that nationwide, contact your United States senators. Here in Connecticut, Senator Blumenthal and Senator Chris Murphy would be your local contacts. But it's very important to understand there are changes here in Connecticut and many more changes on the national level. So other than that, I do want to turn it over to Jane. How are you? Haven't seen you in about a month. And
Hi.
what's new?
Good evening, Lawrence and Stephen and Jim. Thank you for joining us this evening. It's great to be back. I can't believe it's 5 years since we've been doing these webinars. It's a busy time of the year, so hopefully we can sit back a little bit tonight, Lawrence, and just ask questions rather than actually take the floor this evening. But I can't believe we're at the end of another school year. It's been a busy one, and regrettably, I think that next year is going to be just as busy, especially as some of these changes start to trickle down into our school districts. So in addition to being aware of what's happening on a state level and a federal level, I do urge families to be familiar with your local school district budgets and the allocation of those resources and the policies that might be made on a local level to stay informed and use your advocacy skills to engage in conversations at a local level as well. You'd be surprised that the more conversations you have, the more informed you are, the impact that we can have collectively together. So don't be despondent. Continue to speak up and use data and information to provide substance to your arguments, which is something we always suggest you do along the way. But it's good to be here, and thank you, Stephen and Jim, for joining us this evening.
And one housekeeping note, we have a series of questions that we have already received, but if you have questions during the webinar, we would ask that you put them in the Q&A function at the bottom of your computer screen and not in the chat section. The chat section is recorded, the Q&A is not. We have contact information for all of us in the chat section, and this is available on YouTube after, yes, the copy of this will be available on YouTube. So we're very fortunate to have Attorney Jim Funnell, who is a special needs trust and estates attorney, at Brody Wilkinson, which is in Southport. It's in Fairfield, but Southport considers itself Southport. And we're also equally fortunate to have Steve Ehrens, who's a CPA and wealth management advisor at Northwestern Mutual, and his office is in Fairfield, as in Fairfield. So, so we're both, I've known both of them for quite a number of years, and we look forward to learning as much as we possibly can in the allotted time we have on special needs trusts, financial planning, and we'll get to your questions. So without further ado, if Jim, I think we decided you would go first, if you want to give a little background and talk about special needs trusts, general trusts, and then we'll go over to Steve Ehrens, who can talk about the financial piece that goes into these trusts and public benefits like SSI, Medicaid, and other programs that are out there.
Okay. My name is Jim Funnell. As Lawrence pointed out, my office is in Southport. I've been practicing trust and estates law for 38 years, and about 70% of my clients are parents who have kids with disabilities. And I see my role as creating the financial safety net for all members of the family after one passes, but in particular tonight, we talk about special needs trusts. So I think the easiest place to start is, what is a trust? And believe it or not, it doesn't have to come with 60 or 70 pages of densely typed letters. All a trust is one person holding property for the benefit of another. And they can be used for a lot of purposes. Broadly, a trust, a revocable trust, can serve as a will substitute. For tonight's purposes, a special needs trust is a trust that's intended to do really 3 or 4 things. The first is we want to be sure that assets that a parent leaves for a child with a disability are not subject to any recovery claims that the state may have for any benefits that have been provided up to that date. When those 100-cent dollars hit the trust, we want the trust assets to be protected from creditors, predators, and even divorcing spouses that may show up in that child's life. Third, we want to be sure that the assets in the trust do not affect eligibility for need-based public benefits. And last but not least, whatever may be left in the trust when that child with a disability dies can pass back to family or on downstream to that child's children, perhaps, without any recovery claim by the state on behalf of the state or federal government. So the underlying here is that somebody's got to be the creator of the trust, nominally called the grantor or settlor quite often. And that's usually the person who ultimately funds the trust. There also needs to be a beneficiary, and that's going to be in the context of a special needs trust, a child with a disability, and we need somebody to be in charge. And that person is called the trustee. In very broad strokes, a special needs trust comes in many different flavors in many different states. And we've seen the trusts evolve over time. There was a time that for Social Security purposes, the trust had to have language in it advising the trustee, you can use this money for anything that you believe appropriate in the beneficiary's life, other than food, clothing, shelter, and medical. Which kind of begs the question, what happens if the government doesn't show up for any one of those? But we still see those trusts occasionally. They're no longer required, as far as I know. That kind of language is no longer required in any state. It's certainly not required for Social Security purposes anymore. The next evolution of trust language said essentially the trustee can use the money for anything the trustee believes appropriate, but don't eliminate or interfere with eligibility for need-based public benefits, which begs its own set of questions, including what happens if the answer that the government has sucks? And in that case, can't we use private dollars to buy a better answer? If we've got that restrictive language, then the answer quite possibly is no. There's workarounds, but there's a better way to draft these days that's used in many states, most states. And it simply says the trustee can use all, some, or none of the income and principal for anything the trustee believes appropriate, but try to let the government pay all the bills it's willing to pay, and you can step in with private dollars to fill the gaps that we know are going to be left behind. That latest iteration of special needs trust, if available in your state, is probably the best mechanism for drafting a trust of that sort, because it gives the trustee broad discretion to use the funds. And essentially what we're saying with a trust like that is we're telling the trustee, let the government pay for everything the government's willing to pay for. Use these dollars to fill the gaps. And if any answer the government has isn't workable for whatever reason, then use private dollars to buy a better answer where that's a possibility. And the easy thing to point to there is Medicaid, and Medicaid dental in particular. If I get a toothache, I go to my dentist. The dentist says you need a root canal in the crown, and 3 weeks and $5,000 later, I'm good for 30 years. If my son goes in and if he's qualifying for Medicaid, if he goes in and sees a Medicaid dentist, the dentist says the Medicaid answer here is we're going to pull that tooth and you're going to chew with the other side of your mouth for the rest of your life. if the trustee says, I don't think that's a reasonable answer, given that we've got this pile of private dollars here, why don't we buy a better answer? And the rules for these benefits have evolved to allow exactly that. We can buy the root canal and a crown. The rules have evolved to say that we can't, the doctor can't double bill or split bill, where it says this is what I would have charged for the extraction, and we'll bill the government for that, and we'll bill you, the trust, for the rest. If you're going to choose an answer different from what the government has, basically you got to pay 100% of the freight. So I don't know if that's a helpful introduction, but that's the quick and dirty view of what I view as a special needs trust and how it functions.
So what's the difference between a special needs trust and a regular trust? And what if you have one child that has needs and one child that doesn't, or other children that don't? How do you handle the trust situation in those scenarios?
Well, the way I encourage parents to think about estate planning when there's a child with a disability is think of it as two estate plans. One estate plan is the financial safety net that we're creating for the child with a disability. The rest is the traditional family estate plan. How do I take care of my wife if I check out first? How does her estate plan take care of the kids? Let's distribute the share for the child with a disability to the special needs trust we created back in 2025. And let's lay out a different program for a child that doesn't have a disability. And the other programs can be as simple as an outright distribution to a child because they're old enough, they've been kicked by life enough, and if they screw up, it's on them. Another possibility is the American standard, and that is to create a trust for a child that lasts until the age when maturity magically occurs. And this might say 25 or 30 or age 35, the money is distributed. But to use me as the example, my brother Bill as trustee would be told, you can use this money for anything in Charlotte's life that you believe appropriate. But whatever's there at age 25, she gets a third of, no rules attached. The other 2/3 is still in trust, can still be used for anything, but it doesn't belong to her yet. At age 30, she gets another third or half of the then balance. And at age 35, the last bite of the apple comes, and she's got everything she's going to get. The last approach is one that looks at a purely discretionary trust, where the trustee is told he can use all some or none of the income and principal for anything in this child's life, period. And it may last for a lifetime with the intention of protecting the assets from creditors, predators, and divorce, and protecting the assets for ultimate transfer to the next generation through a tax device known as generation skipping. So all of those are possibilities. As a matter of fact, that special needs trust is just a variant of the lifetime discretionary trust. It's just a hybrid version, and we identify it as a special needs trust because it's widely recognized to also preserve eligibility for need-based benefits.
And then I guess the question to Stephen is, once you have a trust, Stephen, how do you then fund that trust?
That's a good question, and that's a good place to start because, of course, we're all out there fighting for whatever benefits we can get. But of course, these benefits in most cases are not going to be enough to provide our children with the life that we want them to have. I look at my own daughter, who is now 32 years old, and she does work and earns a little bit of money, but her expenses far exceed the amount of income and benefits that she is bringing in. So I, with my money, am essentially supplementing her needs and paying for all the things that she needs to give her the life that I want her to have. And all of that works well now because I'm alive. And by the way, I'm not giving her the money because that potentially can disqualify her from receiving these various different benefits from the different organizations such as SSI and Medicaid. So I, for example, am paying her rent. I am paying her phone bill. I'm paying her credit card bill. I am using my money to supplement whatever benefits and income she is generating so that she has this life that I want her to have. So,
Just to quickly interrupt you there,
yeah.
related to dollars, we had a question. Is there a certain amount of dollars that a trust could grow that would disrupt government benefits?
So the answer is no. Once a special needs trust is funded, it can be funded with an unlimited amount of assets, which is different than an ABLE account, which we'll talk about in a minute. So what we're really talking about is funding this trust that Jim is going to draft, that when mom and dad ultimately pass away, typically the assets that they designate to go into that trust will then flow into that trust. And the trustee then is going to act just like I acted during my lifetime and provide supplemental supports for my daughter Liz, paying her rent, paying her credit card bills, sending her on vacations, whatever her needs are that she's not earning or receiving benefits through, will be paid for through the monies that are in the trust. So we need a lot of money. I mean, the truth is, my daughter is 32 and I am 67. It's likely she will be here for 30 or 40 years after I am no longer here. I look at, and I try to help families look at, what do we think the financial need of their child is going to be in the future? What is it going to be in terms of what does it look like now? And of course, we know what the world looks like now, but we won't know, or we don't know what the world might look like in 20, 30, 40 years. Will even these benefits programs still be available? Will their child still be able to work due to their disability? We don't really know. So it's very difficult to try to envision what their financial needs are going to be potentially.
Now, if
So,
you are
yeah.
if you are a trustee, are you also allowed to put funds into the trust?
Anybody can put money into the trust. So there's no limitation. Mom, dad, aunts, uncles, siblings, anybody can put money in the trust. So that's not an issue. Only the trustee can distribute the money for the benefit of the beneficiary out of the trust. And again, they're not typically pulling the money out and giving it to the beneficiary. They're typically pulling the money out to pay for goods and services needed to give the beneficiary the life that mom and dad had intended them to have. Now, the problem is having enough money. How do we have enough money when we start to calculate out 30 years, 40 years of funding? Maybe there will be SSI, maybe there won't be, maybe Medicaid will be cut. What is the cash flow needs going to be of that individual? Generally speaking, the answer is they need to put a significant amount of money into the trust. And what most families do is they typically divide their assets up amongst all of their children because, of course, they don't want to have a conflict where some of the children get more and some of the children get less, because then it creates a very dangerous dynamic, especially if some of the siblings end up being trustees. So, for example, if I had $1 million left, I do have a daughter with special needs. If I had that all designated to my daughter, but I didn't give my other daughter, who is ultimately the trustee, any of that inheritance, she might feel slighted. She might be angry. That would also be an incentive for her to possibly steal money out of the trust and use for her benefit. There are no trust police who are running around making sure the money is spent appropriately. It's up to the trustee. The trustee has a fiduciary responsibility to spend the money per the direction of the trust, which is solely for the benefit of the beneficiary. So going back to the question, how do we fund it? What most people do is they use life insurance. And life insurance is the perfect means to fund the trust because it comes into existence exactly at the moment that we need it, which is when mom and dad die. So I'm not concerned that there's going to be enough money for Liz when I'm alive. I'm not concerned that there'll be enough there for her when my wife is here. What I'm concerned with is that when we're both gone, that there's enough money in that trust, there's enough money left to give Liz the monies that she'll need to have this life that I want her to have. Now, there is a very special kind of life insurance that's perfect for families such as ours who have children with special needs, and that is insurance. It's called survivorship insurance. Essentially, a husband and wife are both together the insureds on these policies. And the way it works is the insurance doesn't pay until both mom and dad die. They both have to die for the insurance to pay. And the reason this is perfect is because I'm not concerned until both of us are ultimately gone. As long as one of us is here, then Liz is going to be just fine. It's only when we're both gone that we want to make sure that there's going to be enough money. And this survivorship policy is much less expensive than a policy on either one of us individually, because ultimately we both have to die. But we will eventually both die. So we can use this as a very cost-effective way to fund a special needs trust and provide a lot of money in that trust to provide supplemental resources for our children with special needs.
Steve, we've received a couple of questions that dovetail with what you're talking about. Are there other kinds of assets like a house, stock,
Sure.
bonds, inheritance?
Yes, absolutely. Any assets can be designated to a trust. So it's not only life insurance, it can be your 401k, which becomes an IRA. Usually when you retire, it can be your home. Any assets that you want to designate to go into the trust can, in fact, go into the trust. In fact, one of the things that we typically try to get people to do is to diversify their assets so that we're sure at the end of the day there is going to be something less. And a truly diversified portfolio is not only a diversified portfolio of investments, but it's a diversified portfolio in terms of life insurance, real estate, investment assets, maybe annuities, a whole variety of financial and physical assets that can ultimately flow into the trust. However, it's important to understand that there is this dynamic of who's getting what at the end. And many of these children, as I mentioned before, might end up as trustees of the trust. It's a likely scenario. And it's important that everybody understands how these assets are going to flow. I typically recommend families to sit down, get together before mom and dad do ultimately pass away, and just lay out exactly. And I'm sure, Jim, you probably make the same recommendation. Let's put all the cards on the table now, because we don't want to have any problems later on. And if there's any misunderstandings, we don't want to have a family that's in court fighting with each other in terms of who gets what. But on the other hand, we also want to make sure there's not too much money going into the special needs trust. So this is something that has changed and adjusted typically along the way. I know what Liz's needs are today, but they may be different in 10 years, 20 years, 30 years. And as long as I'm alive, I can keep adjusting and tweaking the flow of my assets into this trust so that I'm comfortable that the split is going to be appropriate and nobody is going to feel like they've been discriminated against. Jim, what are your thoughts on that?
Just a quick question we had from somebody this evening is they're looking to buy a house and they have two children, both with special needs. And their question is, should they put the house in their children's name? What would be either of your recommendations for that?
I would say no, but let Jim answer that
Yeah,
question.
no, I'd say absolutely no. I want the value to be captured somewhere outside of the child's ownership, and the special needs trust for each child. If I'm trying to preserve eligibility for benefits, the special needs trust is a good place for title to be held. I'm not sure if this is the residence for the parents, depending on age. I'm not sure I'd be recommending a current transfer of the residence to the trust. I think as part of an estate plan that says at the death of the second parent, then the trust goes 50-50 to the two special needs trusts. I think that that's a reasonable way of handling it.
You know, what should be understood when we're talking about public benefits, Medicaid, SSI, these are asset and income limited programs. And what the state of Connecticut looks at with an applicant, are you above or below the income and asset limits for Medicaid? And the federal government does that similarly for the SSI program. And if it's not clear, the special needs trust doesn't belong to the Medicaid recipient or the SSI recipient. It belongs to the trust. So it's not an asset to the applicant or the recipient. And the other thing I want to just point out, what Jim was saying at the beginning, it's, you know, with all the language and possible changes in federal or state law, it's very important to periodically meet with your trust and estates attorney and have have it gone over to see if it's up to date, because our state attorney general, and I'm sure other states as well, will try to grab those assets if they're not properly protected by a special needs trust to offset the cost of care with Medicaid and other public benefits. So it's important that you have a properly drafted trust, have it reviewed periodically, especially if you're coming from another state to Connecticut. I think you want to make sure that the trust conforms to Connecticut law, or if you move from Connecticut to another state, that you want to meet with an attorney in that state to make sure the special needs trust is consistent with that state's law.
And another question we had was ABLE accounts. Could one of you explain what an ABLE account is and the difference between an ABLE account and possibly a trust?
Sure. And there's a lot of confusion about ABLE accounts. People contact me, do I need an ABLE account and a special needs trust? What's the difference? I view ABLE accounts as checking accounts for our loved ones who have special needs. So there are a variety of rules around these accounts and how they work. But prior to 2016, our children who had special needs or adults with special needs could not have any assets in their name, or I say any assets. Typically, it was about a $2,000 asset limit. If they had more than that in their name, they would then be disqualified from receiving any benefits. But in 2016, ABLE accounts were devised under the Obama administration, which allowed these very special accounts to be set up for the benefit of individuals with special needs. And these accounts would not disqualify these individuals from receiving whatever benefits they were receiving. Essentially, to qualify for these accounts, the individual had to have the onset of a disability prior to age 26. If they're getting SSI or Medicaid, they would qualify. Or just simply if they got a letter from their physician stating that they had special needs, they could have one of these accounts. Now, these accounts are set up currently, or I should say set up, they're available in 46 different states, and you can go into any state to open one of these accounts. I currently have an Ohio ABLE account for my daughter, Liz. That account will allow me to make a gift of up to $19,000 a year into that account. And Liz actually can contribute a little bit more than $15,000 a year of her earnings into this account. So you could potentially put about $35,000 into one of these accounts in a single year. However, once the money goes in the account, The money is then invested based on the investment option you select. So, for example, with Ohio, there are 4 or 5 different investment account options that are run through Vanguard. I'm in a Vanguard growth fund, and the money that I've put into this ABLE account is invested then in this Vanguard growth fund. And the nice thing about it is the money grows in the account tax-free. So once the money is in there, there are no taxes along the way. Now, the problem with the ABLE account is that the value of the account can only grow to $100,000. If it grows beyond $100,000, then Liz would lose her SSI. So it's important that you keep an eye on the account, because it doesn't take long if you're gifting $19,000 into this account every year. In 3 or 4 years, you may be up against that $100,000 limit. Now, the other piece of this that's kind of nice is that there is a debit card for not all of the accounts, but many of the accounts. And the Ohio account does have a debit card attached. And Liz runs her whole life through the ABLE account debit card. So even though there's up to $100,000 in the account, I load her debit card with just a maximum amount of, say, $500 at any given time. So when she goes to ShopRite, she swipes her ABLE account debit card. When she goes on Metro North, she swipes her ABLE account credit card. When she goes on to the Cheesecake Factory, she swipes her ABLE account card. So the maximum risk that I would have if, let's say, she were held up or if she lost the card and I couldn't react fast enough, would be the value of the monies that were put onto this debit card. The card also gives her financial independence, which for me, I think is the greatest benefit of the ABLE account. She now understands how money works. She spends her own money, and she has control of some of the money that is there for her to use. I can go online any given day, and I can see where she spent her money. I can reload her card. I can change the contribution amounts that I put in. So I would say this is a no-brainer. Everyone who has a child with special needs should have an ABLE account, but just be aware that with $100,000 maximum amount that the account can grow to, this is not going to be a substitute for a special needs trust. If my daughter Liz, it's currently costing me all in about $5,000 a month out of my pocket to provide to her the life I want her to have, beyond what she's getting in terms of benefits and what she's earning. The ABLE account is not going to be enough because it can only grow to $100,000. So both of these devices, I think, are important. The ABLE account for just her regular spending through the normal course of her regular life, the special needs trust funded at death to provide her a lifetime of income when my wife and I are no longer here.
So I have a
Quick-
question regarding
I'm
kind of
sorry.
dovetailing with this is guardianship versus conservatorship in the state of Connecticut. And this might be a question for you too, Jim. What is guardianship and what is conservatorship, and how does that impact an individual's ability to, for example, have access to a debit card connected to an ABLE account?
Well, the access to the debit card is completely in the hands of the person who's appointed as guardian or conservator. In Connecticut, we have a distinction between what's called the guardian and the conservator. Most states simply call all of those acting on behalf of another in the court capacity a guardian. In Connecticut, guardian has a special meaning. It's under the Intellectual Disabilities Act for individuals who have an IQ of 69 or under. The state law makes it very easy for typically a parent to apply to the court to make decisions for a child. For anyone else with a higher IQ, they're going to have to rely on conservatorship to basically do the same thing. There are voluntary conservatorships, which are typically not contested hearings in the grand scheme of things. That's where a child basically acknowledges to the local judge in a proceeding that, yeah, sometimes I need help making decisions and I want my mom and dad to be the people who help me. That's really what a voluntary conservatorship is. But the beauty of it is the court issues a certificate with a raised seal saying you're empowered as conservator of maybe the person's assets or their person, and they have apparent authority to do anything. And most people are ignorant when they see a piece of paper signed by the court with the raised seal on it, and it looks like the parents can make all decisions for the child, and which is wonderful in the context of a voluntary conservatorship. We can get away with what parents get away with anyway. The involuntary conservatorship is a more structured arrangement because the application to the court is set up in a contested manner. The parents have to show up in court. They have to offer proof that there is an incapacity that affects decision making, and then based on the proofs, the child with a disability has the right, they will be represented, but has the right to contest the parents taking away their constitutional right to self-determination, and all of the due process issues are invoked in a proceeding like that. So it's a much more deliberate, much more thoughtful proceeding to move on. I love the voluntary conservatorship because there's no determination of disability made by the probate judge. So the person can still, in theory, make decisions for themselves, but the parents can walk around with a piece of paper that gives them apparent authority to make all decisions. But so there really isn't a huge distinction between guardian and conservator, other than how it's approached and the IQ of the individual who's involved, the ward of the court. Hope that's helpful.
Jim, any thoughts on using a power of attorney instead of a guardianship or a conservatorship? Voluntary?
Absolutely. I want to start at the least intrusive means of making decisions. If the parent has to make the judgment call with the child, if they can make that decision together. But typically, I want a child, and frankly, it's not just a child with a disability. Every client that I have who's done an estate plan with me, I tell them, look, when your children turn age 18, regardless of what the court says, there's been no determination of incapacity, so they have legal capacity to sign documents, including a power of attorney to name an agent to make financial decisions, and authority to name an agent to make healthcare decisions if they're unable. I want both of those in place for the kid who's going off to college, as well as a child with a disability who may not be going to further education. So that's typically where I want to start. And then the next least invasive mechanism would be the conservatorship, but that's because I want that raised seal on a piece of paper so the parents can walk around and make things happen for their child. The other two, the guardian under IQ under 69 and the involuntary conservatorship, those are the last places I want to go. But certainly the involuntary conservatorship is dead last in the run.
Steve, there's a quick question that came in. If somebody had a 529 college savings account and the family determines that the child is not going to college and use the 529, are they allowed to convert the 529 plan into an ABLE Act account if the child has a disability?
So the answer to that is yes, they can convert it over, but they're limited to the $19,000 a year that is allowed to be contributed into the ABLE Act account. So, but yeah, they can do that. And by the way, if it turns out that the child is in fact going to go to college and the money has been transferred into the ABLE account, they could just use the money in the ABLE account to pay for college. So there's no negative. What I would tell any family who is funding a 529 plan for a child that may or may not have special needs is stop funding the 529 plan. Instead, fund the ABLE account, and then if need be, roll the money from the 529 account into the ABLE account. Interestingly enough, I just was working with someone just this week who had about $200,000 in a 529 plan, and they determined that their child was not going to go to college. And they also wanted to buy second to die survivorship life insurance to fund the special needs trust. And what we were able to do for them is they are going to be able to convert $19,000 a year out of the 529 into the ABLE account, and then they can use the $19,000 in the ABLE account to buy life insurance for the benefit of their child with special needs. So that was a pretty cool little maneuver, because of course, if you just pulled the money out of the 529 account, you're going to have to pay tax and penalty.
This is an interesting question. A family that are looking to set up a special needs trust for a very young child, and the parents at this point do not know the trajectory of that child in terms of the acquisition of skills and development, and maybe that child, given a certain age and different inputs, would be a lot more independent than they foresee and consider them at this point, and might not then be considered to have a disability. If a child is trust is set up as being special needs, but the child is then at some point no longer deemed to have special needs, what impact and implications does that have?
I think I'll at least start the fielding of that question. I'm sorry, I'm having a senior moment already.
It was complicated.
So I'll just interject
Thank you.
here, because that's really the situation with my daughter, is she special needs enough to have a special needs trust? And the answer is the trustee essentially has total absolute discretion to do with that money whatever they want. So if it turns out that, Liz is doing just fine and can manage her affairs and is financially responsible, her sister, who is trustee, can turn around and say, "Hey, Liz, listen, mom and dad set this special needs trust up for you, but it seems that you can manage your own affairs. So we're going to just pull the money out and give it to you. It's all yours. We don't need this trust anymore. We can dissolve the trust. We can give you the money. You're not getting benefits anyway, and you're all set to go." Jim?
Yeah, and I'd argue that in most circumstances where the child is high functioning and maybe will never qualify for benefits, they quite often are still in a position where they're more subject to predation than just about any other beneficiary I work with. And
Correct.
so for that reason, I want it to stay in the trust so that it's protected from creditors and predators and divorce. I want those dollars to be safe. And you're absolutely right that if the trust says, I can distribute all sum or none of the income and principal for anything in this child's life, but don't interfere with benefits. If at any point in time there are no benefits, the trust simply devolves to a trust that says you can use it for anything in this child's life. I would always, for somebody who's very young, I would opt for planning against worst case scenarios, knowing that best case scenarios can take care of themselves because of the latitude offered the trustee in the document.
Is there a ballpark figure, and not to get personal, what's the ballpark figure a family could anticipate the cost of setting up accounts and special needs trusts and the planning involved?
The special needs trust alone, leaving the rest of the estate plan to the side for the moment. Our price point in Connecticut would be an organization called Plan of Connecticut. It's a nonprofit organization that does nothing but serve as trustee of trust for individuals with disabilities, overseen by the Department of Banking and all the other words that you want to hear about a trustee. I think they're the best trustee in Connecticut for special needs trust, but because it's not my brother, I wouldn't choose them first in line. They charge $1,050 as a startup fee for their trust. And in order to put the trust in place, you're going to need a couple of hours of time, 2 or 3 hours from somebody. So you could count on it costing $3,000, $2,500, $3,000, something like that, to put the special needs trust in place. For me, I can't opt for that price point because I'm one of those people who thinks that family takes care of family best. I would want my brother to be the trustee. That means that the special needs trust would need to be privately drafted rather than pre-drafted through a local organization. And that private drafting is more expensive, typically twice as much. So you could easily spend $5,000 on the special needs component. And that's before you look at the family portion of the plan that points all of the assets to the right place, including this child's assets to their special needs trust. So you can spend a lot of money fast in setting up both estate plans for the child with a disability and for the rest of the family.
And is there a minimum amount of money that you would need to have vested or set aside for the trust in order to establish a trust?
Well, establishing a trust and having an operational trust are different things. No trust exists without property, so there's always a recital of something existing. It might be $1 or $5 on a Schedule A attached to the back of the document. That way, this empty basket with all the right words is sitting there ready to receive assets, typically at the death of the second parent. So to me, that's the legal minimum funding. In terms of how much money do you need to actually make a special needs trust work, that's not my bailiwick. That's the financial advisor's world. And I'll turn to Stephen for that one.
And my answer to that is that doing something is better than doing nothing. And people also have to live, and they've got their own lives, and we only go through this rodeo once, and we can't make ourselves insurance poor or investment poor or savings poor. We have to enjoy our lives. So we can only do what we can do. But that's one of the nice things about insurance, is that it's a leveraged investment vehicle. If you were to decide that you wanted to save $1 million to put into a trust, you would have to save $1 million, and that's going to take you quite a while to do. If you started saving at the age of 25, you'd have to save almost $300 a month. If you started saving at 55, it would cost you almost $6,000 a month to save $1 million by the time you're age 65. The alternative to this is buying insurance. And if you buy insurance, it costs a lot less money than actually saving money to put into the trust. So many times I work with families, and we may calculate a number in terms of, based on the child's situation, what we would like to have in the way of assets to flow into the trust. But many times we have to also consider, what can we reasonably afford to do? And based on that, we try to provide as much insurance as we possibly can to ultimately be there to fund the trust at the very end. So something is better than nothing, and there is really no minimum. You'd be surprised, especially if the families are younger rather than much older, if this young family with this newborn who is wondering how special needs their child is and what their situation will be, if they were to just take a leap of faith forward and do something rather than nothing, buy a little bit of insurance now, what they'd find is that the result would be very significant. And if it turns out that the child doesn't need it, then they will have at least created wealth for all of their children. And in many cases, people use insurance as a retirement vehicle, a savings vehicle for themselves as well.
Can you have more than one ABLE account? You mentioned that you can have them in Ohio. Can you have more than one in different states?
No. One account per beneficiary. That's it.
We've had a few questions about Medicaid eligibility and SSI eligibility. It can be overly complex. So I'm just going to give a quick summary. Medicaid, sometime in Connecticut, is called Title 19 or Husky, is an asset income limited program. And it's a funding source for various state programs, healthcare, autism waiver programs, intellectual disability waiver programs that are handled by the Department of Developmental Services. Our state Department of Social Services is the Medicaid agency, and they have information on their website. ct.gov is the state website that will have the Medicaid eligibility. As Steve mentioned, it sounds like $2,000 is considered a lot of money by the state standard, so anything above that. And as far as SSI, that's a federal program. You have to go to the Social Security, it's probably ssa.gov, the federal Social Security, and you'll see that there's Social Security and SSI. Both programs use a similar definition of disability, and they have what's called a listings of impairments. And one of the questions we received was, if my child has Down syndrome, are they eligible? The answer is most likely you have what are called presumptive eligibility, and there are certain categories of disability the federal government presumes you're eligible. There are other categories of disabilities you have to fight like hell to establish eligibility. And for the person who said, what should I do when SSI doesn't respond to me? And the answer is, don't give up. Follow up with the Social Security office, write letters, call your U.S. representative or U.S. senator. Sometimes they will get involved with constituent services by contacting these federal agencies to help move through the red tape. And it's very important not to give up. I've read articles, the Social Security Administration has a habit of denying people who are eligible, should be eligible for Social Security or SSI. And of the small percentage of people that pursue their rights, there's an approximate 70% reversal rate. 70% reversal rate, which means there's a high error rate at the application and initial review. So as they say, you can't fight City Hall. Yes, you can. You just have to have a skilled advocate, attorney, know the eligibility requirements for the state agency benefits, know the eligibility requirements for the federal agency benefits, and most important, know how to access your appeal rights. And there are attorneys and there are advocates who specialize in Social Security cases. I'm not one of them, so I do get a lot of calls and I make referrals to attorneys who handle Social Security. And I might also add special needs trusts. I make referrals to Steve and Jim as well, because I don't handle that aspect of the law.
And I'll offer, I've got the Social Security Blue Book up, and non-mosaic Down syndrome is a listed disability.
So would you say that step one is to find an attorney to help draw up the trust, and then step two is to have a financial advisor help you manage the financial portion?
Well, I see those two things happening typically at the same time, because certainly we need to have a clear understanding of what the special needs trust is. I have parents come into me all the time as Lawrence was pointing out earlier. They come in and say, I've already got a trust for my child. It says for their health, education, maintenance, and support, the trustee can make distributions. The mere fact that they've got a trust isn't enough, and they need to be educated as to what is appropriate and why. And then I'll let Stephen step in here, but I think that those two things parallel, and as a matter of fact, we work well together.
And I have parents coming in and they say, we're actually in pretty good shape. I've got a 529 set up for my child with special needs. I have a brokerage account and I've got some savings bonds, and we're already accumulating a significant amount of money for them. And we thought we would want to set up a trust fund, but we're really not sure how to do that. So clearly they're completely moving in the wrong direction in terms of how to set up their whole structure of their financial assets, in that obviously putting assets in the name of their child with special needs is going to ultimately be a disqualifier. So yes, I'd say both should be done simultaneously. We need to think about where the future lay in terms of what their child's needs might be and how to best financially fulfill those needs. But we also need to think about benefits and fighting for those benefits and protecting those benefits and protecting those assets. Jim made a very good comment before, which I think is very appropriate in my case, because it's unlikely that my daughter will ever get much in the way of benefits. She earns too much money, not that it's so much, but she's essentially earned most of her benefits away, but never in a million years would she be able to manage the money that is going to be left to her in care of the special needs trust. And all you have to do is be her friend, and she would be happy to give you some money. So it's unlikely that her sister is going to pull the money out of the trust and say, hey, Liz, here's the money that mom and dad provided for you. You can clearly manage it on your own. What's more likely is that the money will be there in the trust, protected from predators, creditors, ex-spouses, whoever is looking to take advantage of her, so that she's going to have the money she needs to live her life.
So presumably when you're doing this planning, you need a trustee A, but in the event that trustee A isn't available or in situation 2, then you need a trustee B and potentially a trustee C too, to cover the lifespan of the individual, but also just in case something happens to those trustees and their own lifespan is cut short.
So successor trustees are worth thinking about, but having mechanisms in the trust document to appoint successors if the list isn't long enough is similarly important. I tell parents, put your blinders on and pretend you can see 5 years down the road. If you were to check out on I-95 tomorrow, what's the best answer you've got for the next 5 years? And that's the person you want to name as trustee. And if you've got an obvious second line, great, go ahead and name them. If you don't, let that trustee have the authority. If you're already gone, let them have the authority to name their own successor. Name a typical sibling to have the power to name a new trustee. More important than that, be sure that you as parents who create a trust like this, or siblings who are going to parallel lifespan, presumably, have the authority to remove and replace a sitting trustee if the person that is acting isn't appropriate for any reason. I'm afraid of my brother Bill. We were born and raised in Oklahoma. Family takes care of family and all of that. But the thing I worry about is he's 93 years old. He can't balance his own checkbook, but he promised me he would be trustee for Jimmy. That scares the hell out of me. Somebody's got to pull the plug on that. And if Sally and I aren't around, my wife, then my daughter Charlotte should have that role of policing who is in charge, because Charlotte will never be in charge of that trust. Why? She's the presumptive recipient of whatever's left. She's got a conflict of interest. Not that she would act on it, but the existence of the conflict of interest means she's not a disinterested trustee. She shouldn't have that role. But I can give her the more important role, and that is policing who is in charge.
We've had a couple of requests for where do we go for information about special needs trusts in other states or here in Connecticut. I don't know if either of you want to expand it, but I don't have specific advice. I know the Connecticut Bar Association has a lawyer referral service, and most states have a lawyer referral service. That's an option. There is a program here in Connecticut through the Connecticut Bar Association, Ask a Lawyer. These are brief consultations, often in a public library in various parts of the state. So there are, and possibly sometimes law school clinics. So it's really trying to find the resources out there. I can't say there's a specific website, a specific state agency or local agency, but I have seen the Connecticut Bar Association offer brief consultations. I've seen Connecticut Bar Association through the lawyer referral service. Somebody will say, I need a trust in the state's attorney. You pay a small fee for the referral and you have a meaningful referral. And that would probably be the case in New York City for the person who asked. The New York City Bar Association may be a good starting point. Maybe one of the law school, often the law schools have legal clinics. Some of them do trust in the states, some do tax, some criminal defense. Some special education. It depends from law school to law school. So I don't know if either of you have any resources to add the people who are looking for resources for an initial contact, other than calling Steve Ehrens or Jim Funnell. That's always a good starting point as well.
Yeah, I would say that the best resource I have is probably myself, in that I have piles of information and resources that I make available to my clients, to anybody who essentially contacts me. And then I typically work with people all over the tri-state area and make lots of referrals to those people. There unfortunately is no central clearinghouse that would list all the resources for all the things that people need. I'm sure Jim probably is in the same boat as me. He's been doing this a long time. He's got probably many resources that he refers people to as well.
Yeah, and similar to Stephen, I rely on the people that I've met. But as important as that, I do a lot of work with Plan of Connecticut, and the head of Plan of Connecticut happens to be the head of the National Plan Alliance, and because of that that position, I've got instant access to credible special needs trust attorneys in every state. So that's quite useful. So you're welcome to send me an email and maybe I can help.
We're getting to the point that we have to end tonight's webinar. I want to thank all of the people who've remained throughout the webinar, and there are many, and we thank you for your tonight's participation and your continued participation. I want to thank our special guest, Attorney Jim Funnell, and our financial planner, Steve Ehrens, for their collaborative efforts, thoughts, wisdom, and practical advice. We hope that you found this evening's conversation informative. And if you have the YouTube channel, you can get a copy of this webinar. Most important, I want to thank my daughter, who's off to my immediate right, because without my daughter, Rachel, Jane and I could not put these webinars together. She's the point of contact. She does all the legwork. She does all the technical stuff that I have absolutely no idea what she's doing, but she's doing a great job. And I want to thank her. And the response to our webinars is growing, and we're grateful, as I mentioned before, for those that continue to ask questions, show up. And Jane and I are taking off for the summer. Hopefully we'll be here in September. As I mentioned at the onset, there are changes on the state and federal level that I hope will not adversely affect us. So those are my concluding remarks. We will be in touch about future webinars. We look forward to another year of speakers and topics to help families educate their educational journey and related issues like financial planning. So Jane, Steve, and Jim, I'm turning this over to you on any concluding remarks. So thank you.
Well, I'd like to thank Lawrence and Rachel and also his wife Debbie for this wonderful collaboration that we've had for over 5 years now. It's a great opportunity for us to have insightful conversation and to enhance our knowledge within this field. So thank you, Jim and Stephen, for sharing your expertise tonight in estate planning and the finances behind all of that. It's been a very busy year, a very good year, but busy year. If anybody needs any support or help with regard to advocacy, don't hesitate to reach out, and have a wonderful summer. Hopefully the sun will be shining a lot and we can relax, and we will see you all back again at the beginning of the school year, probably early September.
And Jane and Lawrence, thank you for allowing me to participate, and thank you to everybody behind the scenes.
And I also thank you all. I just want to make one comment before we sign off. And there are a lot of things that we can't control in terms of planning for the future of our children. But if you proceed forward, setting up a special needs trust, putting together a plan for your child's future, one of the things that you will find is it will give you a tremendous peace of mind. You will feel like at least one thing has been taken care of. You'll be able to sigh with a little bit of relief, knowing that your child with special needs is going to be taken care of in the future, at least from a financial standpoint and from a benefits standpoint. So peace of mind is really what this is all about. And this is something that you can control and you should take action on.
Very well said.
Thank you.
Excellent.
Well, thank you, and thank you for our participants. And good night.
Good night.
Good night.
Bye-bye.